Good afternoon. Welcome to today's Brinks, Hofer, Gilson, and Leone V panel, entitled The Patent Examiner Count System and After Final Consideration Pilot with the Mir Pen. You are welcome to comment or ask questions in the chat window to the right of the screen. Questions will be answered at the end of the presentation. If you are applying for CLE credit, please know there will be multiple points in the live V panel where you will be asked to check in and confirm you are watching this online course. This is done through the window below the video screen where questions will be asked throughout the presentation. All questions must be answered in a timely manner to receive CLE credit. If you would like to download today's PowerPoint presentation, you can find the slides in the top left-hand corner of your screen. And now, a Mir Pen with the Patent Examiner Count System and After Final Consideration Pilot.
Thank you, Carolee. We will be first talking about the examiner count system. And in that sense, we're dealing with the United States Patent and Trademark Office, a governmental organization. So it's helpful to understand the structure within the PTO. This knowledge will help us in how and when to contact the examiners at the PTO. To that end, we will discuss first seniority at the PTO. Then we'll discuss production requirements at the different levels of seniority. And then we'll discuss how examiners meet production requirements within the count system. We're first going to talk about the GS levels, or in other words, the general schedule levels. Basically, examiners are hired to the patent office in one of GS 5, 7, 9, or 11, depending on their experience level, their number of degrees, as well as their industry experience. After which, the examiners they advance through the GS levels, and ultimately they will enter either GS 11 or GS 12, which is where they start preparing for partial signatory authority. We'll discuss in a moment what that is, but basically what they do is they take a test to first be able to prepare for partial signatory authority, after which they are advanced to GS level 13, where they enter the partial signatory authority program. That's a program where basically they're being prepared to allow them to sign certain documents within the patent office. They're given partial authority, not entire authority, but they're basically given authority to sign non-final actions, such as non-final office actions. And after they enter GS 14, they enter another program called the Full Signatory Authority Program, where they can, after they advance through the program, they can sign any action. Be a non-final action, final action, or an allowance. After GS 14, an examiner can advance to GS 15, where they're basically termed a supervisory patent examiner, or a SPE. That's where an examiner will supervise anywhere between 8 to 15 examiners. Now, the first question is, why does signatory authority matter? Well, it's really a question of who's the right person to talk to. So you typically need to talk to a primary or a SPE in order for them to obtain an allowance, or in other words, at least convince them, as well as the examiner, that they need to allow the case. So the question is, when and how do you contact the SPE if necessary? So the question is, when do you want to involve the SPE? It is a balancing act. Basically, you don't want to offend the examiner by prematurely suggesting that the SPE be involved. Really, it's basically using your discretion. Typically with more junior examiners, the junior examiner will say, listen, why don't we get our SPE involved? And if that's the case, then obviously you want to follow the lead of the examiner. Now, if the examiner doesn't suggest talking to the SPE, even though the examiner doesn't have signatory authority, I would actually suggest first speaking to the examiner, himself or herself, After which, if you don't come to an agreement with the examiner, then you can suggest to involve the SPE basically just to get an additional perspective. So in that sense, you can first talk to the examiner, and after which you can potentially involve the SPE if you don't think prosecution is advancing. Now we're going to talk about production goals. Now, the production goal for an examiner is based on the average time the examiner is expected to spend examining an application from first action to final disposal. This entire process is called balanced disposal, or BD. Now, BD is important from the perspective of the Patent Office because it's the primary unit used by the PTO to track examiner production. In terms of production requirements, the balanced disposal depends on the class as well as the GS level of the examiner. So more complex technology results in more time being allowed for the examiner to complete the balanced disposal. And obviously, a more senior examiner will have less time. Why don't we look at an example of production goals in different classes? This is basically an example of the assigned expectancies based on the complexity of examination at the GS-12 level. We have our first class, which is class 14 bridges, and that receives 17.5 hours per balanced disposal. The next class is class 202 for distillation apparatus that receives 21.9 hours per balanced disposal. And finally, we'll look at class 725, interactive video distribution systems, which receives 31.6 hours per balanced disposal. So the first thing that you look at, you see that class 14 bridges obviously receives fewer time allotted per balanced disposal. The presumption being that analyzing the art of bridges is less complex than, let's say, a distillation apparatus or interactive video. The next thing we'll look at are the adjustment factors for the various GS levels. So again, we talked before about GS 5 through all the way through 15. And the idea is that you actually have an adjustment factor, what's termed on the screen a position factor, which is basically a multiplier to the what's given allotted for a certain balanced disposal. We're going to now apply the adjustment factors to class 14, which is for bridges. So now a GS examiner, GS 12, receives approximately 17.5 hours per balanced disposal. A GS 7 examiner, his expectancy would be 17.5 divided by his position factor, which is 0.7. So that comes out to 25 hours per balanced disposal. So now with the same technology, in this case bridges, the less experienced GS7 examiner receives more time than the GS12 examiner for a balanced disposal. Looking at the GS14, that examiner's expectancy would be 17.5 hours divided by the position factor, 1.35. So that GS14 examiner receives 13 hours per balanced disposal. So within the same technology area, the more experienced GS14 examiner gets less time than the GS12 examiner. Now, apart from the production requirements, it is important to be mindful of the production calendar. There are two different focuses for the production calendar. The first is called Count Monday. So basically, the entire calendar year is divided up into 2-week periods, termed bi-weeks. Now, each Count Monday, what they do is they look to the production, how each examiner has produced within the previous bi-week. And apart from the bi-week delineation, you also have end of quarter analysis. So at each quarter, 4 quarters within the year, the examiner is also evaluated for the production within that quarter. The end of the first quarter is typically the end of December. The end of the second quarter is typically the end of March. The end of the third quarter is the end of June. And the end of the fourth quarter is the end of September. 2 things to note. The first is, especially with Count Mondays, it's extremely rare for examiners to schedule interviews on Count Mondays. They may like to schedule it the Thursday or Friday prior, hopefully to potentially get some quick agreement or an allowance to maybe potentially use for the production for that Count Monday. The second thing, and arguably the more important, is the end of quarter. But in particular, the end of the fourth quarter, which is actually coming upon us now. Anyone who has a substantial prosecution docket probably anecdotally knows that they receive a lot more calls starting around maybe July or August with increasing frequency. And typically the reason why is because examiners want to meet their production goals for the end of the year. Again, it being at the end of September. So the question is, and we'll talk about this in a moment, how can you maximize that leverage in order to try and advance prosecutions? The short answer is you want to focus on the end of the fourth quarter because it is very important. So now we'll take a look at the example again of GS-14 in bridges. GS-14 in Class 14 bridges. Now, as we said before, the examiner receives 13 hours of credit for that balance disposal, from first action all the way through disposal. And given a bi-week may typically have approximately 70 hours of examining time, it may be the number of 80 hours reduced in the week may be reduced for, let's say, potential administrative credit for, let's say, examiner interviews. So the assumption is that an examiner typically will have about 70 hours in which to account for his production. Now, given that example, you have 70 hours divided by 13, which is the balance disposal. So basically, the examiner needs to, in that 2-week period, have 5.4 balance disposals each bi-week in order to meet the examiner's production. We're going to focus now on slide 11. And I've reproduced a chart that was from the Patent Office. They actually issued this going back around February of 2010. The Patent Office actually revamped the count system. It was actually the first time that they had done it in over 30 years. The last time they significantly did it was back in 1976. Now, the idea behind this was, the thought was that they generally wanted to try and reduce the incentive for examiners to give credit for RCEs. The Patent Office basically wanted to try and give an incentive for more compact prosecution. So in order for them to do that, they had thought that if they provide less credit in the way of a balanced disposal for first RCEs, as well as second and subsequent RCEs, the Patent Office actually believed that they could provide an incentive for more compact prosecution. There was a consequence, which basically, again, anyone who is a substantial docket would know that examiners were taking a much longer time to examine and review RCEs. And this was, unfortunately, in my experience anecdotally, it would take a year or more for an examiner to review an RCE. So the short of it was the RCEs were actually increasing and there was a huge backlog in RCEs. partly because of this disincentive that the Patent Office did when they revamped the count system in February 2010. So, in order to try and provide a new incentive, basically to give the examiners more incentive to pick up the RCEs, the Patent Office has temporarily increased the credit to 2.0 for first as well as second subsequent RCEs. If you take a look at the far left of that chart in slide 11, you'll see its original case non-RCE. The Patent Office at least has temporarily said, we will use this part of the chart for both non-RCEs as well as first and second subsequent RCEs. So why don't we take a look at an example for applying the chart? Now, we have a first action office action, or FAOM, for an original case. In that instance, when the examiner issues that first action, the examiner will be credited 1.25 counts. If the examiner, after that, allows the case, the examiner is credited with an additional 0.75 counts. So basically, this is in the scenario where an examiner will give a first office action, presumably rejecting the claims, and the applicant will respond. And after that response, the examiner will then issue an allowance. So the examiner is basically credited after that response with 0.75 counts. Now let's take a look at a different scenario where the examiner issues, again, a first action on the merits for the original case. Again, the examiner is credited with 1.25 counts. If the examiner, after that, issues a final office action, the examiner is credited with an additional 0.25 counts. So this is in contrast in the first instance where if the examiner allows the case after the first action, the response to the first action, the examiner in this instance will only receive 0.25 counts. Now, if the examiner, if there's some sort of abandonment or some sort of disposal, such as the filing of an RCE or the filing of an appeal brief, then the examiner will be credited with 0.5 counts for the disposal. So first let's look at the RCE. At the filing of the RCE, the examiner is credited with the 0.5 counts for the disposal. Obviously, if the examiner is notified or determines that there's an abandonment, then the examiner again is given 0.5 counts. So again, anecdotally, if you receive a call from an examiner asking if you have filed a response to an action, and if you say, there is no response that was filed, it will give a smile to the examiner's face for the simple fact he has just been given 0.5 counts for the disposal. Now, in the instance of an appeal, an examiner needs to work a little more to get that 0.5 count. Basically, the applicant files a notice of appeal and then files an appeal brief. Now, at the filing of the examiner's response to the appeal brief, then the examiner gets the additional 0.5 counts for the disposal. So, turning now to the recommendations, the first question is, find out whether the examiner has signatory authority. That actually helps in terms of figuring out who your actor is. One example is you can look to the office action. Look to the last page and see who signed the action. Now, if you see the examiner's name and then underneath it, you'll see another person's name, could say a primary or a SPE, and then that second person is signed, then clearly the examiner is not a primary, does not have signatory authority. There is one instance where you can tell if the examiner has partial signatory authority. Again, you look to the last page of the office action, and if you only see one name there, but that name does not include a designation of either primary or SPE, then that examiner is in the partial signatory authority program. It just gives you a sense as to who you should speak to. And again, use your discretion. Determine whether you want to first build a relationship with the examiner before involving the primary or the SPE. One other point is you should try to avoid final rejections. Now, this is probably stating the obvious, but I think it bears emphasis for several reasons. One is you want to avoid final rejections for the simple fact you want to avoid costs in terms of filing, let's say, an RCE or a potential appeal. But the second is you want to try to get a second final action. And I want to go back to slide 11 to explain. So the idea is, let's look at this again. So we have an examiner is given credit for the first action on the merits, 1.25 credits. If in the instance the examiner has to issue another non-final action, the examiner under this count system will receive no credit. So it is in the examiner's interest, obviously, to get you to final. It is in your interests, obviously, to try and avoid final. Again, to avoid the fees, but also, frankly, to try and have the examiner more amenable, because he does not receive any credit for issuing that other non-final. He will be more amenable to speak to you, to try and get the case to final or to disposal, let's say allowance. So in that instance, it is very important for a variety of reasons to try to avoid finality. We'll return now to slide 14, where we look at the instance where you are on final. And the question is, what should you do? Now, there are two schools of thought about what to do when you receive a final. I've spoken to other attorneys, former examiners, and there are two different ways how you can approach a final. The first is to speak to the examiner before you file your RCE, or speak to the examiner after you file your RCE. In my experience, I actually recommend, if you are planning to file an RCE, I recommend requesting an interview with the examiner. Recall that interviews after final are given at the discretion of the examiner. But in my experience, if you call the examiner and tell the examiner that you're planning on filing an RCE, chances are the examiner will grant the interview to you. It is in the examiner's benefit to advance the case if he or she knows you will file an RCE. So you will receive the benefit of an interview. The examiner obviously benefits from the disposal and with the potential easy count in the event of an allowance. Now I want to go back to slide 11 to emphasize that, because this is what I would term the sweet spot for the examiner. Now again, we're on final. The examiner just received the credit 0.25. So now the examiner will, if he knows that you're going to be filing an RCE, he will not only get that 0.5 credit, and under the temporary increase, he can potentially get 2 additional credits. So it is in the examiner's benefit to try and hopefully get the case allowed after filing the RCE. So my recommendation would be the following. Talk to the examiner. Schedule the interview with the examiner prior to filing the RCE, with the goal of at least trying to overcome the pending rejection. In other words, you may not get commitment from the examiner that you can get an outright allowance. Typically, examiners will say, I will review your amendment and perform a subsequent search. But at a bare minimum, your goal should be at this point, prior to filing the RCE, to obtain commitment from the examiner to try and overcome the pending rejection. So now we'll return back to slide 15. And the bottom line is you want to be aware of the timing. You generally want to be aware of bye weeks. It's of moderate importance, but of much greater importance is awareness of when the quarters end. And again, the quarters end at the end of December, the end of March, the end of June, and most especially the end of the end of September. This is particularly relevant now with the end of the fiscal year approaching. So the question is, we're towards the end of September. What should we do? Well, for important cases, I would recommend actually contacting the examiner. And that is in the instance if there is a pending action. Like let's say the examiner is issued an office action that you have not yet responded to. Or even if you have already filed a response to an action. Like let's say the examiner issued a non-final action and you filed a response in, let's say, July or August. It's already popped up on the examiner's docket. So in that sense, it is advisable to contact the examiner. The examiner may be more amenable, particularly now, to talk to you, given that we're approaching the end of September and the end of the production year. And now we'll turn to the After Final Consideration Pilot Program 2.0. This program was launched in May of this year, and it was originally scheduled to end at the end of September. I contacted the Patent Office this morning, as a matter of fact, and they said this program, the 2.0, will be extended, likely within the next 10 days or so. So these comments will, in terms of these final slides, the After Final Consideration Pilot Program will continue for at least to the end of the year. Now, this pilot program is part of the USPTO's ongoing efforts towards compact prosecution. We had spoken earlier where the Patent Office reduced the credit given to RCEs, the first as well as second and subsequent RCEs, in order to provide a disincentive to examiners to just drag out prosecutions with a considerable number of RCEs. This is another example of that. The idea being that you want to reduce the number of RCEs. As an aside, this is at cross purposes to the interest of the examiner in terms of the count system. We looked before, the examiner in the sweet spot is when the examiner receives an RCE and the examiner can get a lot of credit for a case that the examiner is already familiar with. The examiner has already performed the initial search. So in terms of the amount of credit given versus the amount of time allotted, the examiner is given quite a bit of credit for RCEs. So this pilot program is at cross purposes to that. Now, in order to offset that, the examiner is authorized some additional time in terms of a number of hours, 3 hours of credit, to search and consider responses after the final rejection and to conduct an interview. Now, I want to contrast first the pilot program 2.0 with the final consideration pilot program 1.0. Now, the original After Final Consideration pilot program was launched in March of 2012. Now, again, it had the same motivations. The Patent Office wanted to reduce the pendency of applications and hopefully reduce the number of filing RCEs. Similar to the pilot program 2.0, the after final consideration pilot program 1.0 authorized an additional 3 hours to consider responses after final rejection. Now, one of the failings, in my opinion, was that the after final consideration pilot program 1.0 was informal in its process, in that it required no special request to invoke the program. So really the problem was, from a PTO standpoint, they didn't know how the program was going. They weren't able to track it in their internal tracking procedures to determine how effective the pilot program was in reducing the number of filings of RCEs. The examiners themselves were tasked to determine whether an after final response was appropriate for this program and decide whether the after final response could be considered within the additional 3 hours provided. The problem was the after final consideration program 1.0 wasn't uniformly implemented. And again, it was difficult for the patent office to track how non-uniform the implementation was, for the simple fact that there wasn't a special request. So that gave motivation to the after final consideration pilot program 2.0. The first thing was, there's basically a form that you have to formally apply. It's form PTO SB/434 that identifies a submission as an after final consideration pilot program 2.0 submission and requests consideration under the pilot program. The second requirement is that the amendment is to at least one independent claim that does not broaden the scope of the independent claim in any aspect. Another requirement is that there's a statement that the applicant is willing and available to participate in any interview initiated by the examiner concerning the response. And as an aside, one of the problems with the lack of uniformity was in the pilot program 1.0 was that the examiners were contacting the applicant's attorney pro forma. They would just call, leave a message, and if the if the applicant's attorney didn't call back, the examiner would simply say the applicant's attorney was unavailable, and so the pilot program 1.0 won't be instituted. So this pilot program 2.0 is trying to avoid situations where there isn't a true faithful contact of the applicant's attorney. Point 4 is that there aren't any additional fees. There aren't any ordinary fees, so it's just really the ordinary fees after final. And the final requirement is that you file the application, the after final response via EFS. Now, this is an example of form PTO SB 434. I show it only, it's really just filling out a form. It takes virtually no time, but obviously it's important for PTO purposes to file it, not only for their internal tracking procedures, but also to make sure that you're entered within the program. Now here are some of the requirements. Applicants need to file a response under 37 CFR 1.116. Another requirement is that the amendment to at least one independent claim does not broaden the scope of that independent claim in any aspect. This is very important. You cannot broaden the claim. And the standard under which to determine whether a claim has been broadened is the same standard as when you examine whether a reissue claim has been broadened. Another point is that reissue applications and reexamination proceedings aren't eligible under this after final consideration pilot program. Finally, and this really goes without saying, is that an interview is recommended. Now, really the $64,000 question is the examiner's discretion and how will it be applied. Examiners have discretion to decide whether the response can be fully considered under this after final consideration pilot program 2.0. More specifically, the examiner determines whether any additional search that's required can be performed within that allotted time, within those additional few hours, in order to determine whether that application can be allowed. Now we're going to look at the processing of requests under this after final consideration pilot program. The examiner first reviews the submission to ensure that it complies. If it doesn't comply in any aspect, the examiner can immediately bounce it. It's really a quick way how the examiner can not consider this submission as part of the pilot program. And if that's the case, if the submission is bounced, then the submission is treated as an ordinary after final response. If the submission complies, then the examiner performs the initial review. This is where the examiner's discretion comes into play. The examiner determines if an additional search is necessary, and if so, can the search be performed within the additional time allotted under the After Final Consideration Program 2.0. If the examiner reviews it and said, listen, it's going to take me 5 to 10 hours to review this submission. I can't review it under the pilot program. And if that's the case, then the examiner will basically treat it as an ordinary after final response and mail an advisory action. Now, if the examiner makes a determination, says, yes, I can review this submission, potentially perform an additional search, and determine an allowance within the time allotted, the examiner then will perform a search. One of two things will occur after performing the search. The examiner may say, yes, I performed the search, and given the subsequent search, I make a determination that the case is allowable, and the examiner issues the allowance. The other instance is where the examiner determines that the amendment that was filed doesn't place the application in condition for allowance. So that's where the examiner contacts the applicant's attorney, and schedules an interview. After the interview, the examiner will then make another determination, either issue the allowance, or if the examiner remains unconvinced, the examiner will issue a response to the submission according to the current after final practice. The Patent Office actually issued a circular giving instances where the pilot program was appropriate. The first instance is where the amendment places the application in condition for allowance. Now, this is, as an aside, this is contrasted with simply incorporating a dependent claim that was deemed allowable into an independent claim. So for example, let's say that a final action rejects claim 1, but allows claim 2. So the applicant's attorney, in the after final response, simply amends claim 1 to incorporate all of the limitations from claim 2. That is not a proper amendment under the after final consideration program. It would be treated as a normal after final response where the allowance would be issued. However, a slightly different amendment that places the application in condition for allowance would be where you incorporate limitations from objected to claims into the independent claim, although not all of them. So you have a claim of different scope than what the examiner considered allowable. We'll talk about a couple of examples of that in a moment. But the issue is, if that new claim, with some, although not all, of the limitations that were deemed allowable are incorporated into the independent claim, the examiner will then review it to determine if that amended claim with some, although not all, of the incorporated limitations can be allowed after a limited search. Another situation is where the amendment can be deemed to place the application in condition for allowance, even if new claims are added, which, according to the Patent Office guidelines, the Patent Office says, yes, you can add claims. I'll talk about in a moment, but my interpretation as a practical matter, it is unlikely if applicant tries to add new claims. And when I say new claims with wholly new additional limitations that have in a scope that the examiner hasn't seen, it is unlikely that the examiner will consider it proper for this after final consideration program. Another example is where the amendment can be determined to place the application in condition for allowance by adding a new limitation. Again, we'll talk about this. It's a limitation that the examiner has not seen so far, but it's a limitation that the examiner may consider as require only a small amount of additional search. And finally, the last sample situation is where you have, let's say, an affidavit that for one reason or another that was rejected, that was previously submitted, but that for one reason or another was rejected. Let's say a 131 or 132 affidavit. And then you can submit a supplemental declaration that corrects the defects that the examiner noted in rejecting that previously submitted declaration. So now the question is the guidelines. Where would the after final consideration pilot program be appropriate? One example is where there is allowable subject matter. Again, in the example, let's take one example where claim 1 is rejected on final, but claim 2 is allowable. The examiner has said claim 2 is allowable, and let's say claim 2 has two limitations, A and B. The after final consideration program may be appropriate if, in amending claim 1 in your after final response, you incorporate only one of those limitations in claim 2. Let's say you only incorporate limitation A from claim 2, but do not incorporate limitation B. That would be appropriate for the after final consideration program. Another example would be, let's say you have in the final rejection claims 1 and 2 rejected, but claim 3, which depends on claim 2, is deemed allowable. In that instance, if you don't want to incorporate the limitations from claims 3 and 2 into the independent claim, and you only, let's say, want to incorporate the limitations from claim 3, that would be another instance where the after final consideration program would be appropriate. Another instance would be where you would have a narrower limitation to a limitation that was currently before an examiner. So let's say the examiner has rejected claim 2, but the examiner may indicate in the office action that he is taking a fairly broad interpretation and potentially an unduly broad interpretation of the limitation in claim 2. You may consider narrowing the limitation in claim 2 to remove that overly broad interpretation by the examiner and incorporating that into the independent claim. That would be a good way to present an after final consideration pilot program response. And at this moment, I want to mention, if anyone has any questions, feel free to include those questions in the chat box. A couple of additional thoughts. Again, it remains to be seen whether the after final consideration pilot program 2.0 will lead to further allowances. Nevertheless, I do think it is an option to be considered in certain cases, particularly where it is beneficial to participate in the program. If the applicant is accepted into the program, the applicant is at least able to interview the application when the claims aren't found allowable. The interview is most definitely beneficial for a potential amendment with an RCE. So in this instance, let's say the applicant files a response, an amendment. The examiner performs the search. The examiner says, this case is still not allowable, I will conduct an interview. In that interview, the applicant's attorney can determine to say, I understand now what the examiner wants. I can narrow my claims slightly more. And I can use that narrowed amendment with the filing of an RCE. So really, in effect, you've almost received an additional office action. You've received the audience of the examiner an additional time. And hopefully, you can advance the case so that when you file your RCE with presumably slightly narrower claims than what you filed in your after-file response, you can advance prosecution and hopefully get to allowance. And the final thing is there's no additional fee to participate in the program. So other than the normal after-final fees, you can still participate with the program with no additional cost. Before I proceed to the questions, if there are any questions, that's great. If not, I do have a couple of additional comments, and that is, especially with the examiner count system, and why don't we go back to slide 11? Because again, this is the most important aspect. I'd like to talk about this both with respect to originally filed applications as well as continuation applications. And this is something we haven't touched on, but I think it's relevant. Let's focus on the left side of the figure where we have the original case. And again, the first action on the merits, the examiner is given 1.25 credits. Now, in an originally filed case, this is the first utility filing in this application. The examiner is obviously given that credit. Contrast that with a continuation application. So you have a parent case that has presumably been allowed or perhaps abandoned, and you have filed a continuation application. That is another instance where you may want to consider contacting the examiner before the examiner issues the first action on the merits. Now, in private pair, you can receive a determination when the examiner is scheduled to issue the first action. So in very important cases, you may want to consider contacting the examiner slightly before, perhaps a month, 6 weeks, prior to that date, to simply call the examiner and to say that you're available to talk. The reason why is twofold. One reason is for applicant. The second reason is for the examiner. For applicant, there may be certain instances where you may want to have a very clean prosecution. There may be some ministerial issues. The examiner may have a question, And hopefully you can advance prosecution while trying to reduce the record. Conversely, take a look at the credit. The examiner, and typically the examiner who is assigned the continuation is the same examiner that was assigned the parent case. So the examiner is already familiar with the case. So particularly when you file a continuation, where the claims may be slightly broader, the examiner is already familiar with the subject matter, has already performed a search. So the examiner will potentially receive a considerable amount of credit, even though the examiner has not had to perform that much of a search. In that instance, it is beneficial to the examiner to allow the case on first action, because the examiner will receive a considerable amount of credit without very much work. Sometimes we face in prosecutions examiners we may consider be gaming the system. Now obviously our knowledge of the count system will hopefully try and avoid that. In those instances, if that's the case, our knowledge will help us either contact the examiner's supervisor if we feel the examiner is unnecessarily delaying prosecution, either contacting the examiner's supervisor or the group art unit director. But the knowledge that we have in terms of the count system will enable us to avoid that. Now, one question is, does the count system give the examiner an incentive to give a restriction to get you to file a divisional? That's an excellent question. And the short answer is yes. And it's an indirect way. Let me explain. The examiner is allotted a certain amount of time to perform a search. So let's say you have 20 claims and the examiner issues a two-way restriction. Claims 1 through 10 and claims 11 through 20. If the examiner issues a restriction, the examiner only needs to search for 10 claims. So that first action on the merits, as well as the final action, will require the examiner to perform less work for the simple fact that he's examining fewer claims. A more specific instance of that is where you receive species restrictions. And sometimes you may get, let's say, a 5 or 6 way species restriction. And again, that's the way the examiner, the short answer is that's the way the examiner is looking at the count system to try and reduce the amount of work while still getting the counts. In those instances, if you receive a restriction, either species or a general restriction that's it's either too many categories, too many, like let's say way restriction, you can push back on it. So the short answer is yes, that is actually a way the examiner can potentially game the system. In one instance, if the examiner is giving you, let's say, a 10-way grouping restriction, that is beyond the pale. And that's something when you need to contact the supervisor. You need to get the supervisor involved and at least reduce the amount of restrictions. One other question is, how do you find out the examiner's bi-week schedule? That's another good question. And basically, the U.S. Patent Office publishes that. It's basically, it's every 2 weeks. They divide it. It's basically every bi-week. And if you want to send me an email, apen@brinkshofer.com, I can send you the schedule for that. But it's basically every 2 weeks. And you'll generally know for the simple fact the examiner will tell you, I have a deadline. Either the deadline's their count deadline or it's an internal deadline. So I want to make sure whether we have any other questions. One other question is, oh no, we've already answered that question. Great, so we have no further questions, and I want to thank you for participating.
Thank you for watching the Brinks-Hofer-Gilson-Leon V-Panel today, the Patent Examiner Count System and After Final Consideration Pilot with the Mir Pen. If you are applying for CLE credit, confirmation will be sent to your email address within 4 to 6 weeks. Again, thank you.